We lost our home of 23 years to a hurricane. The water came up to the ceiling of the first floor. We lost furniture, photographs, documents, the kitchen my husband had built with his own hands. We started over at 67 years old. We found a new home. We moved in, and the first thing I did to make it feel like ours was plant flowers, marigolds, zinnias, knockout roses along the front beds. A small act of putting down roots again after the flood had pulled them all up. 6 months later, our HOA sued us for $100,000. I need you to understand something about what flower beds mean to a person who has just lost everything in a natural disaster. They are not decoration. They are not about curb appeal. They are a declaration. They are you saying, I am still here. I am still building something. This place is mine now, and I am going to tend it. Frank and I had been married for 41 years when the hurricane came through. We had weathered things before: job losses, medical scares, the death of both sets of parents, a child who went through a hard decade in his 20s and came out the other side okay. We knew how to weather things. We had not weathered 4 feet of standing water in our living room. We had not stood in the driveway watching the water still rising and realized we had underestimated how serious this was going to be. We got out with the dogs and the medications and the external hard drive with the family photographs and basically nothing else. We had not weathered coming back 3 days later and walking through a house that smelled like everything we had ever built together had been submerged and was now beginning to rot. Frank stood in the living room for a long time. He is not a man who cries easily. 41 years, and I can count on one hand the times I have seen it. He stood in the living room of our ruined house, and he cried. I put my hand on his back, and I stood there with him, and we both understood at the same time that we were not rebuilding this. We were leaving it. At 66 and 69 years old, we were starting over. And then we did what people do: we started over. The new house was supposed to be the rest of our lives. We were retirees. We weren't starting careers or raising children. We were starting a morning routine that included coffee on a porch and a garden that bloomed in the spring. That is what we were starting. $100,000 lawsuit over flower beds. Let me tell you everything that happened. Because what started as something that felt absurd became something that revealed exactly what some HOAs are willing to do to the most vulnerable homeowners, the ones who are already tired, already stretched, already starting over. My name for this story is Helen. I am 69 years old. My husband Frank is 72. He spent 30 years as a commercial HVAC technician before retirement. I spent 26 years as a school librarian in the same district where our children went to school. We are not wealthy people. We are comfortable, careful people who saved for retirement and paid off a mortgage and planned for a quiet later chapter. We have 2 adult children who live out of state. We have 4 grandchildren who visit in summer. Frank coaches a youth fishing league on Saturday mornings. I grow things, always have. Houseplants when I was young, then a vegetable garden, then flowers when I had more time. Gardening is the closest thing I have to meditation. Our previous house was in a neighborhood south of Houston where we had lived since we were in our early 40s. We raised both kids there. We knew the neighbors on both sides well enough to exchange casseroles when someone was sick. It was the house where everything important happened to us, right up until the water came in. The hurricane hit on a Tuesday. We had evacuated to my sister's house north of the city. When we came back 3 days later, the first floor was devastated. Frank walked through the door and stood in what used to be the living room and didn't say anything for a long time. I stood behind him and watched the waterline on the wall and thought about the Christmas mornings that had happened in that room, the birthday dinners, the specific creak of the floorboard near the front door that I had known for 23 years. We were not going to rebuild. We had looked at the numbers and looked at each other and made the decision that at our age, starting over somewhere else was the right choice. We sold the lot, cleared the site, and began looking. It took over a year to find the right place. We wanted a ground floor unit with yard access. We wanted a community with maintained common areas because neither of us wanted the responsibility of significant outdoor upkeep anymore. We wanted quiet. We found Pelican Bay Estates, a planned community about 20 minutes from where we had lived. The HOA dues were reasonable. The property was well kept. The neighbors we met during our walk-through seemed friendly. We made an offer. It was accepted. We moved in the November after the hurricane, 13 months after losing everything, and in February I planted flowers. Pelican Bay Estates had an HOA with a standard set of governing documents, covenants, conditions, and restrictions that covered everything from exterior paint colors to acceptable fencing materials to the permitted species of street trees. I had read them. Frank had read them. We were not people who moved into a community without doing our homework. The covenant section on landscaping required that all planting beds be maintained and consistent with community aesthetic standards. It did not specify which plants were permitted or prohibited. It referenced a community guidelines document that was supposed to be available from the management company, which I had requested and received before we moved in. The guidelines document was 11 pages. It covered lawn care schedules, mulch depth, acceptable ground cover species in various zones, and general language about maintaining a neat and harmonious appearance. It did not contain a list of prohibited flowering plants. It did not state that new planting beds required architectural committee approval, or rather, it contained a sentence about modifications to existing landscaping requiring review, which I had read and which I had interpreted as covering structural changes, not planting annuals in an existing bed. That interpretation, it turned out, was not the HOA's interpretation. November, I cleared the 2 front beds that had come with the property, a sparse arrangement of generic shrubs that had seen better decades, and replanted them. Marigolds for autumn color, knockout roses along the back of the bed for height, some creeping phlox along the edges. I added a layer of fresh, dark mulch. I stood back and looked at it and felt, for the first time since the hurricane, like I had made something that was mine. Frank came out and stood next to me. Frank said, "That looks good, Helen." I said, "It's a start." Frank said, "A good start." It was a good start. For 4 months, nobody said anything. The flowers bloomed. Neighbors complimented the beds. I was planning spring additions, some ornamental grasses along the far edge, a climbing vine for the trellis I wanted Frank to build. Then the letter arrived. Nobe, March. A formal violation notice from Coastal Property Management, the company contracted to manage Pelican Bay Estates HOA. The notice stated that we had installed landscaping improvements without obtaining prior architectural committee approval, in violation of the community's covenants. It cited the relevant provision. It demanded that we either remove the unauthorized plantings or submit an approval application with a $25 fee within 30 days. Frank and I sat at the kitchen table and read it together. Frank said, "Flowers need prior approval." I said, "Apparently." Frank said, "Since when?" I said, "Since we planted them, I suppose." I was not entirely surprised. I had read the guidelines, and I knew there was a gray area. I was annoyed, but I was not panicked. We would submit the application. We would pay the $25 fee. The committee would look at our beds, find that they were neat and maintained, and actually improved the look of the property, and approve them. That is what I thought would happen. I submitted the application in April. I included photographs of the beds. I included information about each plant species, their growth habits, their maintenance requirements. I wrote a cover letter explaining that we had planted these beds as part of settling into a home we had moved to after losing our previous home in the hurricane, and that the beds were maintained and consistent with the community's aesthetic standards. 5 weeks later, the committee's decision arrived. Denied. The denial letter contained a single paragraph of reasoning. The planting scheme was inconsistent with the community's established aesthetic guidelines. No specific plants were identified as problematic. No specific guideline was cited. No alternative was proposed. I said, "Inconsistent with the established aesthetic, what does that mean?" Frank said, "I have no idea. Everything looks consistent to me." I called Coastal Property Management and asked to speak with someone who could explain the denial in specific terms. The representative I reached was polite and unhelpful in equal measure. The coastal representative said, "The architectural committee makes those determinations. I can note your inquiry, but I can't speak to their specific reasoning." I said, "Can I appeal?" The coastal representative said, "You can resubmit with modifications." I said, "What modifications would lead to approval?" The coastal representative said, "That would be at the committee's discretion. I can't advise you on that specifically." Frank walked out to the front beds after I got off the phone. He stood there looking at the marigolds and the roses and the phlox in the afternoon light. Frank said, "What do they want us to do?" I said, "They won't tell me." In September, a law firm representing the HOA filed suit against us. The lawsuit sought up to $100,000. I want to tell you what it feels like to be a retired couple in your late 60s and receive a legal filing that says you owe potentially $100,000 for flower beds. I want to tell you because I think it is important to understand the human dimension of what HOA enforcement does to real people. We did not have $100,000 in accessible liquid savings. Our retirement funds were in accounts that were not designed to be emergency litigation resources. Our income was Social Security and Frank's pension. A $100,000 judgment against us would have been financially catastrophic. It would have required us to liquidate retirement assets, potentially sell the house, potentially, at 72 and 67, face a housing situation neither of us had planned for. When I read the lawsuit for the first time, my hands were shaking. Not from anger, though the anger came later, from fear. The specific fear of a person who has already lost one home and is looking at the possibility of losing another. The lawsuit was detailed in its accounting. $200 per day from the date of the original violation notice forward. The total at the time of filing was listed as at least $3,000, representing 15 days, with the note that violations had been ongoing for considerably longer. The clause seeking up to $100,000 appeared to be the maximum possible damages under the governing documents and applicable Texas law, presented as a ceiling rather than a likely outcome, but a ceiling that was nonetheless very clearly stated. The lawsuit also sought attorney fees. Frank came in while I was still sitting at the table with the papers. Frank said, "How bad is it?" I told him the numbers. He sat down. Frank said, "For flowers." I said, "For flowers." Frank called our son in Colorado from the kitchen while I sat at the table with the papers. I could hear both sides of the conversation. Our son's voice going quiet when Frank told him the number, the brief silence that meant he was calculating, the offer to help, Frank's voice getting firmer when he said we'd handle it ourselves first. After the call, Frank came and sat down across from me. He put his big work-worn hands flat on the table and looked at me. Frank said, "We're not doing this again." I said, "We're not doing what?" Frank said, "Losing a home. We are not doing it again." That sentence settled something in me. The fear was still there, but underneath it something else had arrived. The same stubbornness that had gotten us through 35 years of hard things. The same quality that had made Frank stand in a ruined house and cry, and then call the insurance company, and then call the realtor, and then start methodically to take every step required to get to the next place. We were not going to be taken from another home. Not by water. Not by a lawsuit over marigolds. The next morning, I called our son in Colorado. We did not handle it ourselves. Not because we couldn't read documents or ask questions, but because the legal system is not designed to be navigated by people without legal training, and the other side had a law firm that had done this before. We needed someone who had done it too. A neighbor down the street, a woman who had moved in 2 years before us, knew the community well, and had been silently sympathetic since the violation notice arrived. Gave us the name of a local attorney who had handled several HOA disputes in the region. The attorney, Miss Rivera, reviewed the lawsuit, the denial letter, the community guidelines, and the covenant language in one afternoon session. She called us that evening. Ms. Rivera said, "The covenant language and the guidelines document are both vague enough that the committee has broad discretion on approvals." That's the bad news. The good news is that broad discretion, when exercised selectively, is a legal problem. I said, "What do you mean by selectively?" Ms. Rivera said, "If the committee has approved similar landscaping improvements for other homeowners while denying yours, that's potentially an equal protection issue and possibly a breach of the association's own duty of fair and uniform enforcement. I need you to do something for me." I said, "What?" Ms. Rivera said, "Walk the neighborhood, look at the front beds on every house, take photographs, note anything that looks like a modification to the original landscaping, added plants, new beds, changed ground cover, anything that differs from what the lots looked like when the community was built. Frank and I spent a Saturday morning doing exactly that. We walked every street in Pelican Bay Estates with a camera and a notepad. What we found was that modifications to front landscaping were common, very common. There were raised beds with ornamental grasses on at least a dozen properties, flowering perennial borders, seasonal annual plantings in beds that were clearly not part of the original development landscaping, a trellis with climbing roses on a house 4 doors from ours that had been there, based on the plant's size for several years. We brought Miss Rivera more than 60 photographs. Miss Rivera said, "This is exactly what I needed. This community has approved or tolerated landscape modifications on a significant number of properties. The decision to cite and sue you specifically requires an explanation. And the explanation they've given so far, inconsistent with aesthetic guidelines, doesn't hold up when their own neighborhood looks like this." Miss Rivera submitted a discovery request to the HOA and Coastal Property Management, seeking all records related to landscape modification approval applications over the preceding 5 years. What came back, after a delay that required a follow-up motion to compel, was revealing. In the 5 years of records provided, the Architectural Committee had approved 43 landscape modification applications without the specific conditions placed on ours. Of those 43 approvals, several included planting schemes that were visually similar or nearly identical to our beds, marigolds and roses and low-growing ground cover in existing front bed areas. Not one of those applications had been denied. Ours was the only denial on record in 5 years. Ms. Rivera looked at that and said something I had been thinking but hadn't said out loud. Ms. Rivera said, "This pattern suggests they didn't single you out for the flowers. They singled you out for some other reason. And the denial of your application was the mechanism." I said, "What other reason?" Ms. Rivera said, "That I don't know yet, but I intend to find out." What came out in the further discovery process was less dramatic than a specific motivation and more ordinary in its awfulness. The Architectural Committee had a new chair who had been in the position for 8 months and who appeared to be applying the modification standards more strictly than his predecessor, but not uniformly. Applications from established neighbors who had served on committees or attended board meetings regularly had sailed through. Our application from new residents who had not yet built those relationships had been reviewed with a different standard, not a conspiracy, a bias. The kind of bias that operates through discretion when discretion is not constrained by clear standards. Ms. Rivera filed our formal response to the lawsuit and a counterclaim alleging unequal enforcement of the community's aesthetic guidelines. The counterclaim changed the atmosphere of the dispute. Up to that point, the HOA's law firm had been operating with the confidence of a party that had filed many of these cases and expected them to resolve in a predictable way. The homeowners, faced with the cost and complexity of litigation, would remove the offending plants, pay a reduced fine, and the matter would end. That had apparently been the pattern in previous enforcement actions. What they had not accounted for was that Frank and I had already lost one home. We were not going to lose anything else without fighting for it. The counterclaim documented the 60-plus photographs of other properties with approved or tolerated modifications. It documented the 5-year approval record showing 43 approvals and 1 denial. It alleged that the denial of our application was arbitrary and constituted a breach of the association's duty of uniform enforcement, and that the subsequent lawsuit had been filed in bad faith against homeowners who had submitted a good faith application and received no actionable guidance on how to come into compliance. Ms. Rivera also reached out to a local television news team that covered HOA disputes with our permission. Frank and I agreed to speak on camera. The segment ran in early December. The reporter had spoken with several of our neighbors, including the woman who had originally recommended Miss Gay Rivera, who were willing to say on the record that they had made similar landscaping modifications without any approval process and without any consequences. The HOA's management company declined to comment on pending litigation. On camera, I said what I needed to say. I said, "We survived a hurricane. We lost our home of 23 years. We moved here to start over, and the first thing I did to make this place feel like home was plant flowers. That is all we did, plant flowers. and we are being sued for $100,000. The response to the segment was significant. Emails came to the station from other HOA homeowners across the region who had similar stories. A city council member whose district included Pelican Bay Estates issued a statement saying her office was reviewing the matter. A state representative who had been working on HOA reform legislation contacted Ms. Rivera's office. Within the community itself, the atmosphere shifted. A neighbor who had served on the board for 3 years reached out to us privately. A former board member said, "I want you to know that not everyone on the board agreed with how this was handled. Some of us tried to stop it from going to litigation. We were overruled." I said, "What can you tell me?" A former board member said, "I can tell you the vote to authorize the lawsuit was 3-2, and that the 2 who voted no have both since resigned from the board." That information went directly to Ms. Rivera. In February, 3 months after the lawsuit was filed, 5 months after our application had been denied, and a lifetime after the hurricane had taken our first home, the HOA's law firm filed a notice of non-suit. The lawsuit was withdrawn. I was sitting at the kitchen window when Ms. Rivera called to tell me. I could see the front beds from where I was sitting. The marigolds had died back with the winter, the way annuals do, and I had already planned what I was going to plant in spring. I had written it on the notepad next to my coffee cup. Zinnias along the front edge. Salvia for the hummingbirds. The knockout roses already established and needing nothing from me except a little trimming. I had been planning that spring garden as an act of faith because I had decided we were going to win, and I had let myself plan as if winning were already done. The HOA's attorney released a brief statement. The association had decided not to pursue the litigation further after reviewing the full circumstances of the matter. The full circumstances of the matter included a counterclaim that documented systematic unequal enforcement, 63 photographs of approved comparable modifications, 5 years of approval records showing ours was the only denial, 2 board members who had resigned in part over the decision to authorize the lawsuit, and a television segment that had been shared thousands of times on social media and generated enough public attention that a city council member and a state legislator had both made public statements about the case. The flowers stayed. The HOA also initiated a review of its architectural modification process. Under the settlement terms that accompanied the withdrawal, which Ms. Rivera had negotiated before they filed the non-suit, the committee was required to adopt written criteria for evaluating landscape modifications, publicly available to all homeowners, with specific standards that would allow any applicant to understand what was required before submitting. No more broad discretion with no written basis for decision. No more single committee chair making determinations with no documented standards. Coastal Property Management, the management company, was not renewed at the end of their contract year. The board voted 4-1 to seek a new management company. I don't know the specific reasoning behind every vote, but I know that the events of the preceding year had not made Coastal's position easy to defend. The architectural committee chair, who had denied our application, stepped down from the position in March. No formal statement was made. The neighbor who had told us about the board vote called us when it happened. The neighbor said, "He's out. Thought you should know." I said, "Thank you." The 2 board members who had resigned over the lawsuit authorization were replaced at the spring election by 2 residents who had been vocal about the need for clearer, more consistent enforcement policies. Our legal fees were partially covered by the settlement terms. Not fully, Miss First. Rivera had been clear with us from the beginning that full fee recovery was unlikely, and it wasn't. We spent more than we had planned to, but we also spent less than we would have without her, and we kept the house and the garden. Frank built the trellis in April. The climbing rose is starting to spread. There is a moment I keep coming back to from the whole experience. It was early on, before we had an attorney, before the counterclaim, before any of it. Frank and I were standing at the front beds in the evening, after we had received the lawsuit papers. He was quiet for a while, the way he gets when he is thinking through something. Then Frank said, "You know what gets me? We have been through so much worse than this. The flood, the move, starting over. This is just a bunch of people with bad judgment and too much power. We have handled worse." He was right. We had handled worse. But I want to be clear about something. Not everyone who faces this can handle it the way we did. We had retirement income. We found a good attorney. We had a neighbor who knew the right name to give us. We had the energy and the time and the stubbornness to fight it. Other people don't have all of those things, and the HOA's law firm knows that. They know that most people will back down when faced with a $100,000 lawsuit over flower beds. That is why they file them. The flowers are still there. Marigolds and knockout roses and creeping phlox along the edges, with fresh mulch every spring. Every morning I have coffee and look at them from the kitchen window. They look exactly like what they are, a declaration that we are still here, still building something, still putting down roots after the flood pulled them all up. Nobody is going to take that from us. Here is what I want anyone watching this to understand, especially if you are a homeowner in a community with an HOA. When you make any improvement to your home, any modification to landscaping, exterior structures, paint, anything, check your governing documents before you start. Find the section on modifications and architectural review. Find the application process. Yes, even for flower beds, even for things that seem obviously fine. Submit the application and wait for the approval before you spend money and time on the improvement. I know it feels bureaucratic for what is in some cases a question of where to plant zinnias. I know, but the application creates a record, and the record protects you. If your application is denied, ask for the reason in writing. Ask what specific standard or guideline your proposal failed to meet. Ask what modification would result in approval. If they cannot or will not answer those questions, that is information. Document it. And if you are facing an HOA lawsuit, particularly over an amount that is dramatically disproportionate to the original violation, find an attorney who handles HOA matters. Look for evidence of how the same rules have been applied to other homeowners. Walk your neighborhood, take photographs, pull the approval history through a public records or discovery request. Disproportionate enforcement that is applied to some homeowners and not others is a legal vulnerability for the association. Know your state's laws. Us DAO. In Texas, the property code permits HOAs to file suit to enforce their covenants, but it also imposes requirements on how those suits proceed. The existence of the authority does not mean every use of it is legally sound. And one more thing. What happened to us got public attention in part because we were elderly, in part because we were hurricane survivors, and in part because the image of a $100,000 lawsuit over flower beds is so obviously disproportionate that it generates a reaction. But the same machinery that came after us comes after people without our visibility, without our resources, without neighbors who happen to know a good attorney. Those cases do not make the news. Those cases end with families paying fines they don't owe or removing improvements they were entitled to make because they didn't know they could fight it. So I want to hear from you. If you are a homeowner in an HOA and a lawsuit like this came for you, for flowers, for a paint color, for something that seemed perfectly reasonable to you, what would you do? Would you fight it? And what do you think should happen to HOAs that file $100,000 lawsuits against elderly hurricane survivors over marigolds? Leave it in the comments. I read every single one.